And let's move on with the second session of this conference, which is called Is EU Copyright Fit for the Digital Age? And we are going to look into the challenges, the gaps, the issues that we are facing from a policy, a legal, and an economic perspective. And your moderator will be Giuseppe Abbamonte, who is Media Director in DG CNECT. Giuseppe, the floor is yours.
Good morning, everybody, and thanks very much, Harry. So a few introductory remarks, and then I will call the other panelists on the floor. So, digital technologies, including AI, have fundamentally changed how creative content is produced, distributed, and consumed. This phenomenon creates new challenges for the copyright framework, which must adapt to these changes. The EU copyright framework is constantly evolving to ensure its rules remain fit for purpose in the digital age. A key example is the directive of 2019 on copyright in the DSM, in the Digital Single Market, which introduced key rules for the monetization and licensing of content online and rules on fair remuneration for authors and performers. Our policy compass is set to protect human creativity, ensuring creators are rewarded for their work and thrive in the digital single market. On the other hand, and there is something which was mentioned before, given the competitiveness imperatives, we must ensure that copyright rules support digital technologies rather than stifling them. And this requires striking a careful and continuous balance between the prerogatives of the right holders and the needs of users of created content and innovators. So our speakers today will be Mr. Maciej, First Advocate General to the Court of Justice of the European Union. Please, Mrs. Ms. Antanina Garansvili, Lecturer in Economics for the Guildhall School of Business and Law in London. Mr. Martin Senftleben, Professor of the Institute for Information Law at the University of Amsterdam. And Ms. Séverine Dusollier, Professor in the Law School of Sciences Po in Paris. So the first speaker will give the keynote speech is Maciej, and he needs no introduction because he's a celebrity in our world. So he will highlight the evolution of the court's copyright case law. Mr. Spotzner is uniquely positioned to speak on this subject. He's been directly involved in several leading cases, ranging from Stichting Brain on communication to the public, Pelham 1, I believe, on the exceptions, and more recently in Quantum on the application of copyright protection to works of applied art. So his expertise has provided an invaluable contribution to the development of the court's copyright case law. So, Mr. Spotzner, please, the floor is all yours.
Thank you very much. President, for this introduction. Dear colleagues, ladies and gentlemen, it is both a privilege and a responsibility to speak before you today here in Alicante at the headquarters of the EU IPO, a key agency in the enforcement of intellectual property rights. As the theme of the conference aptly suggests, we gather at a moment of a significant transformation in the landscape of copyright within the European Union. This transformation is driven in large part by the central role of the Internet in the dissemination of copyright works. This intersection of new technologies with traditional legal frameworks has presented both opportunities and challenges that require us to rethink how IP is regulated, protected, and enforced. New technologies have challenged traditional premises on which the law, namely EU law, has been based for decades. As we know, social changes often precede legislative reform. Legislators respond by introducing new laws or amending existing ones, and ultimately courts like the Court of Justice settle interpretative disputes. The Court of Justice has played a pivotal role in this process, shaping the contours of copyright law through its landmark rulings. These judgments not only impact copyright holders, content sharing platforms and users, but also agencies like EU IPO and public authorities at large. Looking back and bearing in mind the experience of the last 20 years, let us look ourselves what have proved to be the biggest challenge related to the internet. And based on my experience, I have identified several issues that I would like to share with you today. The internet, it's probably self-evident, but the internet has completely modified one of the fundamental notions of every legal system, that is the notion of territoriality. The distinction, what is territorial, what is extraterritorial, has become blurred. New technologies, new digital technologies, enormously facilitate the retention of information, the transmission of information, and access to information. And I have the impression that we do not yet fully realize how much these phenomena are turning our current economic and social concepts upside down. Another observation resulting from the case law on IP law concerns the exhaustion of digital works. In the seminal Tom Cabinet decision, the Court of Justice refused to apply the principle of exhaustion to digital copies. Yet this decision revealed another occurrence. I mean here that from the point of view of the user, in the digital world, traditional ownership does not mean a lot. As law students, those who are lawyers here, were taught about the difference between ownership and our forms of use, like license lending. In a digital world, this distinction does not make sense, or at least has a completely different dimension. When we read a book, we can see the difference whether we own the book or this is the book taken from a library. By contrast, when using a digital content, for example, software, it makes no difference to us whether we own it or we are merely authorized to use it. The experience stemming from the case of the court, especially concerning the e-commerce directive, rethinks our existing liability rules, and I mean here all types of liability. Looking at our case law today, one can conclude that the paradigm of liability responsibility has changed significantly. Under a traditional approach to responsibility, it was always essential to identify who was responsible for which wrongful act. In the case of wrongful acts committed through the use of new technologies, this picture is more nuanced and much more complicated. The experience shows that the responsibility of a specific perpetrator, tortfeasor, has less importance. This implies the so-called primary liability does not play a crucial role. What really matters is the secondary liability, that is, the responsibility of those who do not themselves act unlawfully, but who provide for a mechanism that either enables or facilitates the unlawful act or amplifies its consequences. For example, on the internet, it is clear from a practical point of view that it is always easier to issue an injunction against an intermediary than against an infringer himself. First, it is often difficult to identify the infringer, and secondly, in the digital world, the sole identification of the infringer does not in itself end the infringement. The uploading or downloading of illegal content may be done automatically. It follows that from the perspective of the injured party, the liability of the actual perpetrator tends to be irrelevant. What matters is the effect, in the other words, how to ensure that the damage does not continue or increase. And finally, our experience today clearly shows what the use of new technologies has invited us to reconsider the existing interplay between various fundamental rights. In the majority of cases that the Court of Justice is dealing with, the essential question is how to strike the balance between several conflicting fundamental rights. And I would like to illustrate today, it's still 8 minutes left, in relation to the case law of the Court of Justice. I will start with the case VCAST. Even though it was rendered almost 8 years ago, I find it important to understand some developments that followed. In the VCAST case, the court addressed the scope of the private copy exemption under Article 5.2b of the InfoSoc Directive. VCAST, an Italian company, allowed users to remotely record television programs for private use via the internet. The court found that the retransmission made by VCAST constituted in itself an act, a communication to a different public from that of the original transmission, and thus fell outside the private copy exemption. This judgment underscores the necessity for strict interpretation of exceptions to copyright, ensuring that they do not undermine the exclusive rights of right holders. And here I cannot resist the temptation to refer to pending case, even though in principle I'm prevented from discussing pending cases sub judice. But since my opinion was already published, I think I'm entitled to present to you the legal problem under consideration. The question in this case, this is HP Netherlands case, the question is whether a subscriber to an on-demand internet streaming service whereby protected works are communicated is reproducing those works within the meaning of Article 5, where the subscriber has the possibility of using the services also offline. And we all use it. I mean, I refer here to Spotify of Netflix. We can listen being online, but we can also store it on our iPhone or computer. And the question is that if we do it, whether we are using a private copy exception. And my proposal to the court is the negative. I propose to the court that this service involves those works being saved in the memory of the subscriber device in such a way that they could only listen to or watch them during the specific period of time and for which they were communicated. The service provider, by using technological measures, retains full control over the works. Therefore, we are not dealing here with a private copy. It's another act of communication. And this case soon should be decided by the court, but reveals another phenomenon of IP protection in the digital world. It is true that, as I said in the beginning of my speech, that the internet enormously facilitated the transmission of information and also the transmission of works protected by various IP rights. While on the one hand, one could therefore conclude that the violations of IP rights have become facilitated. But on the other hand, when one looks at the way in which many platforms operate, it appears that the right holders have obtained new means over how to control the way we are using these works. Just to give you an example, when I download a movie on Netflix, I can watch it offline, but whenever I'm moving from Poland to Luxembourg, the system immediately identifies that I change my location, and the watching is no longer possible. Let me refer to another case, which is the progeny of VCAS. It's the case Auxilion and the role of intermediaries in communication to the public. This case concerned an internet protocol television service known as IPTV, consisting of making available to commercial clients, namely hotels and stadiums, the necessary software and hardware allowing the customers of those commercial clients to record and to replay TV programs. In that case, first, the court found that a copy protected works made at the initiative of an end user, but which is made available to an indeterminate number of users who wish to view the same content, does not come within the private copy exception. Similar to the situation in VCAS, such a service must be considered as a separate act of communication to the public. And secondly, the court examined whether the IPTV service provided, which only offered the technical means for users to record and replay television broadcasts, could be considered as performing an act of communication to the public. The court found that it could not, as Auxilion did not play an indispensable role in providing access to protected works. Let me refer to another case, which is, as I said in the beginning of my speech, that over the internet, it's not essential to identify a concrete tortfeasor. It's important, I emphasize the importance of the secondary liability of those who facilitate the violations. But nevertheless, the very important case of the court Quadrature du Net 2, there was a reference from the French Conseil d'État, emphasized that especially as regards criminal liability, it is sometimes necessary to identify or to try to identify the infringement. That was certain contradiction between two lines of case law of the court. On the one hand, the case law on data protection saying that we cannot reveal under any circumstances the identity of the user, of the owner of the internet connection, and on the other hand, the need to protect IP rights, in this case copyright. So the court tried to reconcile and said that we cannot accept the system of absolute immunity, of systematic immunity, because if we cannot reveal anything, then all offenses committed over the internet could be never detected, unless self-incrimination, if someone admits that it was done. And let me at the end refer to another pending case, and this case concerns, first of all, neighboring rights. Master of Ceremonies said that we should not forget about neighboring rights. That's the pending case Meta Platforms Island. Meta Platforms, this case raises the question whether the use of press publication in the context of social networks must be regarded as being covered by the exclusive rights of reproduction and communication to the public under Article 15 of the Copyright Directive of 2019. And the case is pending, but as some of you remember, this provision contains an exclusion of individual posts, and this is the case about Facebook. And my proposal to the court is that whenever we are dealing with an individual post on Facebook, but which is accessible to everyone, this is no longer an individual post. If Facebook uses an algorithm to propose the post is no longer individual, and the exception does not apply. So individual post is only where we are, if the author himself or herself decides to whom this post should be available. In conclusion, the court ruling served as a clarion call for all of us to remain steadfast in our commitment to protecting IP rights. They remind us that while the digital age presents new challenges, the fundamental principle of copyrights remain as vital as ever. I sincerely commend the EU IPO for organizing this conference, bringing together such a diverse group of experts representing all the stakeholders implicated in the challenges that I have been referring to. Its role is essential to ensuring that the IP rights are enforced in an ever-evolving digital landscape. For my part, I can assure that the Court of Justice is ready to meet these challenges and to strike the right balance between all the difference at stake. Thank you very much.
Thank you very much, Mr. Sputzner, for all the inspiring overview on the evolution of the Court of Justice and all the insights, the generous insights on the pending cases, which I listened to you with enthusiasm and extreme and keen attention. And now I would like to move on to the next speaker, so Antanina, who will share the perspective of an economist on copyright's role in the creative industries and its impact on innovation. So the title of her speech will be Copyright at a Crossroads, Trends, Challenges for the Competitiveness of the Creative and Innovative Sectors.
Thank you, Giuseppe.
You can stand up if you don't mind.
Right. Thank you so much. It's a great honor to be on this panel and to be able to represent the voice of economists, copyright economics. I did start my career in intellectual property economics as a trainee back more than 12 years ago here at EU IPO. And later on, my career evolved at World IPO, Padova University, UNCTAD, Bournemouth University. And my perspective today here focuses on the economic role of copyrights in sustaining competitiveness and innovation in Europe's creative sectors. So I will speak a little bit on economics theory point of view and some empirical research. So let me start with the first slide. Creative industries in the EU are highly significant. In fact, they do, we can call them one of the cornerstone industries in the EU economy. They alone account for more than 17 million jobs in the European market, generating nearly 7% of the GDP. So this really creates a central role and makes it very significant in this context of new, rapid digital transformation. As we can see, a very large portion of our economy is going to be directly affected by it. What is the purpose of copyright from economics perspective? Well, we can distinguish several key purposes. Why do we have this legal right that helps, that really imposes specific monopoly right? So the first purpose, of course, is to protect the original works of authorship. So the authors are able to reap financial benefits from their efforts, from their creations. That is not the single purpose. Copyright also incentivizes creativity and innovation for the public good. So public interest is also very much out there, not just the private interest. We want the authors to be able to reap financial remuneration from their works. At the same time, it will foster the creativity. And of course, in line with economic reasoning, copyright very much facilitates the market exchanges, serving the purpose of enabling intermediary interactions, right? Facilitate market exchanges, make the selling of the works possible. So it's very much about balancing private and public interest. And graphically, we can, it's a delicate task to calibrate how strong the copyright should be, because too strong copyright inaction will also stifle innovation, not only too weak. So it needs to be optimal. And here, as economics perspective, I should emphasize the importance to categorize copyright into different sectors. We know there are different sectors, of course. Copyright protects various creations on the spectrum from artistic paintings creation, audiovisual and media, publishing and books, also software, databases, and IT. All of these softwares may need difference in approaches. They do have different, also it may vary in the spectrum of where we lie in time, in digital challenges, digital revolution as we are right now. So there is no one-size-fits-all approach. Market failure. Why do we have copyright in the first place is really in economics what we call the market failure. It is the situation in which free market fails to allocate resource efficiently. In terms of copyright, we know that the public goods, they can be very easily consumed simultaneously at a zero marginal cost. It can be difficult to exclude people from using it without paying. This is so-called economics free rider problem. So public goods, yes, this is the classical motivation for having the copyright. Also, other market failures, we can talk about information asymmetry, another market failure. We know that the platforms, especially in the current economy, business models, platforms, they hold more knowledge than individual creators would. So this is where information asymmetry arises. Platforms hold more knowledge, more power in that sense. Externalities, normally we would speak about positive externalities, cultural and educational benefits. Not everything can be monetized as an effect of creative and cultural sector outcomes. And they not necessarily need to be monetized, yes. Effect of architecture, effect of public creative works. Part of it can be monetized, part of the effect will simply be out there for the public benefit. So we have to be aware of this. And fragmentation, we do have 27 very different markets in the EU, and we might risk under-scale digital distribution. In terms of technological disruption, digitalization has made it much cheaper to create and distribute content, but it also has made it harder for creators to control how their work is monetized. So streaming and platform models have shifted a significant share of value towards large intermediaries who control the data, the audience, and the algorithms. Generative AI pushes this even further by raising new questions about authorship, originality, and how creators will be rewarded. And finally, as data becomes a core input for creative production, we see new market features, new market failures also emerging around access, concentration, and value capture, right? So for instance, data access asymmetry, as we see, of course, in user behavior, data consumption data, advertising data, all of that is more shifted on the side for the big platforms. And some, thank you, and some empirical evidence. Well, we know there are 360 million Europeans who use internet on a daily basis. 50 million of these Europeans also use some illegal content. Yes, they admit doing so in IP perception survey. The share is even larger among young people. One of the discoveries I have in my own empirical paper where I explore leading reasons for the online TV piracy confirm this, that the price and instant availability are the key reasons why anyone would engage in consumption of illegal content. We know also from IP perception study that actually 80% of Europeans would prefer legal content if an affordable option is available. And 65% consider it acceptable to pirate when content is not available. So this is where the EU market fragmentation issue comes really into play. So in order, as one of the channels to reduce potential illegal consumption. And second case study also comes from academic paper, which I have worked on together with economists from EU IPO and EPO. So we see that we explored a sample of nearly 300,000 EU firms. We discovered that 10% of them use some additional IP protection. Additional IP protection, we mean registered IP rights such as trademarks, registered designs, or patents. And we see clearly that the firms, of course, normally they are not SMEs, they are larger firms, but they tend to have higher turnover and more employment. So here we can see a snapshot from the paper dataset. Here they can firms either combine on an EU level registered IP rights or just national IPRs. A leading IP right, not surprisingly, is the trademarks used as additional support for the copyright. And what are my takeaways on this very short presentation? That the copyright should not only reward past creativity, it must enable the next generation of innovation. And it seems this line of thought is very much in line of what the audience gathered here today would say. Economics perspective supports integrated IP portfolios. They very much would drive competitiveness. We can see there is a demand to complement copyright with registered IP rights. And yes, EU copyright in the future should evolve towards complementarity, flexibility, and inclusiveness. Thank you.
Antanina, if you don't mind, so if you can stay there, because I would like to ask you a question. So,
yes.
So thanks very much for the a very, very stimulating presentation. But if you were to choose a single most impactful aspect that requires the attention of the regulators, what would it be?
Well, I would say that holistic approach is very, very important in this case. As copyright and creative industries, they do not function in a vacuum, of course. They are part of the broader economic ecosystem. And likely the very, very key issue that I would say is important is looking into fragmentation, solving the fragmentation issue of the EU digital market, really. Yes.
Thank you very much.
Thank you.
Thanks. And now, so let's move on. So the next topic is highly relevant, particularly from the perspective of creators and performers. The directive on copyright in the DSM included an entire chapter on fair remuneration in exploitation contracts of authors and performers. So the core objective was to strengthen the position of these professionals as the weaker contractual party and ensure they receive fair, proportionate remuneration. And something which is important is that the member states enjoyed flexibility in implementing these provisions in national laws and have seen different approaches concerning the principle of appropriate and proportionate remuneration. So I would like to give the floor to Martin now to tell us, to give his presentation, which is called Pay per Play, How to Shape Appropriate and Proportionate Remuneration in Online Worlds. Martin.
Thank you so much, Giuseppe, and also thank you so much, EUIPO, Harry, and Veronique, and the wonderful copyright team here. It's a pleasure to be here and share a couple of thoughts with you. As the word reconciling in the title already indicates, there are competing policy objectives here. I have them here in a nutshell. When you look at the top line, the first one has already been mentioned a lot today, so no doubt we need fair remuneration for authors, also for rights holders. Antanina has just referred to the important reward and creativity, creatorship function that we have in copyright law, so no doubt about that. But there is also cultural and copyright value in the AI innovation step. I'm referring here to culturally diverse AI systems. So when we refer to high-quality AI systems, then from a European perspective, this means AI systems that reflect European cultural expressions and values. And the moment to achieve that goal, the moment is now. If we miss the train, we will get AI systems where lots and lots of European cultural values are simply forgotten. And I say this because the next generation of AI users, the Gen AI natives, the generation that is born now. I'm a generation that remembers a world without internet. When I tell my students, I remember a world without internet, they look at me like, oh my God, you are so old, yeah? But the same, we remember now the switch from a world without Gen AI to a world with Gen AI. To the Gen AI natives born, now it comes naturally. Literary artistic creativity starts with a prompt, and then you add your creativity. So if we don't get our highly valued European cultural diversity into these systems right now, then with all we discuss here, lots of our cultural history, heritage will simply be forgotten. And this is in AI innovation, so we have to get this right. So how do we get this right? There's always light, of course. We see promising licensing initiatives at the moment. I will turn to those in a second. And then I dare proposing something that perhaps could attract some attention in the future. So I guess you all agree there's a very important current trend, a mega trend, you could say, is licensing. Doesn't come as a surprise, of course. We have the text and data mining rules from the 2019 Copyright Directive. There's a general exemption of text and data mining in Article 4, general in the sense that this can also cover commercial AI training. But as we all know, via an opt-out, rights holders can reserve their rights, and EUIPO can play a role there, of course, in making visible what opt-outs and so on have taken place. So the opt-out mechanism is, of course, a mechanism that we can turn into something productive as an invitation to conclude licensing agreements. That's very much how I personally have interpreted the collective opt-outs declared by collective licensing organizations. Of course, CMOs have it in their DNA to grant licenses for a diverse repertoire. On top of that, when we can believe current developments, you have seen the ruling from the Munich Regional Court, there are questions outside of the text and data mining discussion. So the whole issue of memorization, embeddings in the Gen AI models that reflect copyrighted materials to such an extent that we can speak about reproduction in the model itself. These are things that, if we can follow the precedent from Munich, would also require licensing. So very clearly, licensing has an important role to play here. It has also been mentioned that there are fascinating, really large-scale licensing deals. The Universal Music Group Udio deal has been mentioned earlier. We have done a little bit of digging at the Institute, looking into what's going on. Here's an overview. And the intention was not to put this in a form that you could actually read it. The intention was to show there is lots and lots going on. There is so much going on that I couldn't stick to my personal rule that the minimum font size should be 28. So there is lots and lots going on in the CMO world, in the world of rights holders. So this looks promising. When we revisit the policy metrics from that perspective, I still must say it's not sure. It's not sure that we will achieve these two policy goals with just licensing. So don't succumb to the temptation to say we just leave it to the market forces and the hidden hand of the market will just solve this for us. It's not that easy. When we look at fair remuneration for authors, I give you more details in a second, but it's not clear that the money that is made in negotiations between industry branches will somehow end up in the pockets of individual authors and performers. Not clear. And when we look at the cultural diversity of AI systems, well, from a transaction cost perspective, if you are the Gen AI trainer and you have limited time and resources, you negotiate with the big ones. You negotiate with the big right holders because this allows you in just one deal to obtain quite a lot of materials. Why should you negotiate with thousands of indie labels, thousands of small production houses, if in just one go you can get all the music repertoire from Universal Music Group? So there is a bias in this regulatory approach in favor of the big right holders. And the big right holders can also be collecting societies, so I'm not saying that there is no diversity in the repertoires of big right holders, for sure. But still, if we want to have the full European diversity of cultures in the AI systems, not sure that this model will do the job. So once again, you hear very often at the EU level, it's solved, it's all licensing, it's fine. We don't know whether this will lead to the results. Does it lead to desirable results for artists? Also not sure, so here's what happens. So let's say we have a very promising license at industry level, the license I've referred to, if you can believe the press and so on, this Universal Music license is really a fascinating, a big step, but it's a license at industry level. So if you are an artist in that space, then first of all, if the contract that you got years ago was a buyout contract in the sense of a one-time honorarium, then the license deal concluded now will do nothing. If your deal includes a royalty component, you first need information on how much money has been made. And according to my sources, many of these deals concluded don't even refer to licensing. They are data delivery contracts. So whether these are traditional licensing contracts is the next thing. I'm saying this because many artists will have to refer to copyright contract law, which we have in the CDSM Directive 2019, wonderful rules on copyright contract law. But again, empirical studies, whether these are studies from Germany, the Netherlands, other countries that have experience there, show that individual artists struggle with copyright contract law, in particular because of the blacklisting risk. You might win a case based on copyright contract law, you might get extra remuneration, but in this small little sector where you do your work as a film director or something, you will be blacklisted because you are the difficult person bringing the claims. So whether there is additional income for authors, performers, not sure. No worries. I wouldn't let you go without solving this problem. So here's how you solve this problem. I would predict the future trend is on output. We have lots of attempts about input regulation in the sense of trying to take regulatory steps in the area of AI training. But the future, I tell you, is output. So what can we do in the output regulation? As a starting point, I add nuances in a second, but as a starting point, if we want to really realize the potential of European cultural diversity, the first step must be freedom for AI trainers to use copyright-protected materials. Far-reaching freedom to let them do their job, because what they can do best is developing high-quality AI systems, and they need lots and lots of diverse cultural materials for this. And I'm not only referring to the companies from abroad that perhaps look a bit controversial from a European perspective. So I'm also referring to Mistral in France and so on. I mean, let them do their job. They know how to build these systems, but we need freedom for this. And perhaps we need a couple, in addition, of must-carry rules, that a couple of cultural diversity must go into these systems. That's the starting point. Oh yeah, is this starting point achievable under the copyright three-step test? Yes, it is. I mean, this is for the copyright nerds in the room. I have studied the three-step test for quite a while. Believe me, I have done proper studies on this, what you read now, and on several occasions that this is not possible because of the three-step test. Not true. Let's not limit the policy space before we have even started this discussion. So once the AI systems are fully up and running and developed and high quality, and these systems are brought to the market, this is where we put a levy on the Gen AI system. That's the moment where we make them pay. And once they have and this means everybody, whether that's a US company, a Chinese company, a European company, they are all subject to the same rules. The moment they provide AI services, products in the marketplace, they have this payment obligation, and the AI revenue is distributed directly to authors and right holders. So how does that work? We can take as a template the single equitable remuneration in the phonogram sector. So we have a mandatory payment for literary and artistic AI output. This payment, this AI fee, must be at a sufficiently high level. Don't underestimate the potential of this. I'm not referring to peanuts. If you want, you can set the AI fee at 1,000 euros for every prompt. And that allows human creators to compete with the systems. Or you put it at 1,000 euros monthly subscription fee. I don't think that the creative people themselves want to pay this, because the more you are using Gen AI for your own creative practice, the less you like a rule saying 1,000 euro per prompt. But the potential for doing this is in there. I'm not referring to peanuts. So once we have collected this, this goes as a mandatory money stream to collecting societies, collective rights management, and then part of the revenue, according to the repartitioning schemes, goes to the creators and, of course, also to rights holders. So through the policy prism, this solves all the problems. This solves all the problems. Final point, I'm over time. Sorry, Giuseppe. Final point, what's the interplay with individual licenses? Nobody wants to kill individual licensing. So if we take this AI levy as a standard scheme, then following as a model the extended collective licensing rules, we can say, okay, if you don't like that standard scheme, you can opt out. You opt out of the standard scheme and you enter in the individual licensing. The thing is, if a rights holder opts out, under these conditions, then an author can control, do I have more money at the end of the day? If every month you have 1,000 euros on your bank account under the standard scheme, and after opting out and having an individual license, it's only 500 euros, then you know that you would have been better off. So we have an important benchmarking function here, something which in copyright contract law is always very precious to have. So thank you so much. This was a bit fast. Here are the references. Thank you.
Martin, stay where you are. So you have already anticipated my question, but I will ask it again. Just to make sure I understood you correctly. So, in your opinion, could this system based on AI levies coexist with licensing agreements concluded by individual right holders, and how? So, can you expand a little bit on this idea of the opt-out?
Yeah, thank you so much for the question. So that was in fact the last point. So, of course, nobody wants to kill individual licensing initiatives. It's good when the market forces do their work and we find negotiations there. The idea is that once we have this output-based remuneration, we can take this as a baseline remuneration. So as an artist, you know this is what you have for sure. This is what you get from your collecting society for sure. But then the idea is if you're a production company where your copyright and so on is administered, if they say, well, we think we are better off when we enter into individual negotiations, we think we can even get more revenue via individual licensing, then you can opt out. And then the advantage of having this baseline output remuneration is that as an author performer, you can compare the results. You know what you had before the opt-out, and you can see what the revenue is that you get out of this licensing deal, which also means that exploiters of your creative work entering into licensing have to make sure that at the end of the day, sufficient money flows back to the authors and performers, because otherwise they will be dissatisfied because under the standard scheme, they had a higher level of remuneration.
Thank you very much indeed. Thank you. And now time has come to move on to the next speaker, Séverine. So the next topic ties directly into the balance between copyright and other fundamental rights. While creators should be remunerated to be able to continue their creative endeavors, their creations are valuable for society as a whole, and it is why copyright is not an absolute right, but is subject to exceptions and limitations. And the EU legal framework includes several exceptions aimed at supporting public interest objectives, such as research, cultural heritage presentation, and the need to balance copyright with other fundamental rights. So Séverine, professor in law at Sciences Po, will engage with us on balancing exceptions, fundamental freedoms, and open access. Séverine, the floor is yours.
Thank you so much. I would like first to thank the EUIPO, Harry and Veronique and all their team for having invited me here. It's a great honor to be speaking to such a large and distinguished audience. So you see that my mandate is really, really ambitious and broad. So allow me to focus mostly on copyright exception. And what I would like to do is just try to reflect on what has been going on in copyright exception at the EU level in the last 15 years. And I would like to point out two evolutions that for me, I think have been really key in shaping the copyright as we know it today in a very different way from where we were standing in 2001 with the InfoSoc directive. And I will be mixing the evolution of law, EU law, and also how that law has been interpreted by the Court of Justice with one of its most important representatives here. So actually my point is just to try to highlight those evolutions. The first one, and I think it's sometimes it's a bit unnoticed in the reflection on copyright. I think the first one is the fact that the exception has changed status. They were, in 2001, when the InfoSoc directive was enacted, I think they were considered as tolerated uses. You know, those were this list of uses that member states knew that were considered as exception, but they were seen, the most concern was that they were seen as a threat. And then they could be open doors on the internet for unconstrained, uncontrolled uses, and the work could be circulated on the internet without any possibility for copyright owners to get it back. And so we had to control those cases of uses and exceptions, and we could allow them, but under strict conditions, and those strict conditions should be interpreted strictly. I think it has changed recently. It has changed through the 2019 CDSM directive. I think it's changed the way we look at some exceptions, because those exceptions have been seen as some uses that are really important and enabling instruments to foster a knowledge society. And I say knowledge society, not to say knowledge economy. That was the title of one communication of the European Commission that started that process in 2009, Copyright in Knowledge Economy, that actually talked not about a lot of copyright exclusive rights, but a lot about copyright exceptions, and I replace it to knowledge society because my point is exactly that actually it's not only about economy, it's not about market, it's about organizing the public sphere in culture, creativity, and knowledge. And we can see that as the exception that have been step by step put at the core of EU regulation are organizing some sort of access, collective of public access to works through education, through cultural heritage institution, for persons with disabilities. The art of print and open works regimes are ways to move beyond the market and trying to promote access to works for the European public and citizens. Another evolution is the fact that legitimate expression of users is not only confined in some exception, but those exceptions themselves becomes rule and becomes mandates for the platforms to allow that expression to be made before it might be filtered, censored, etc. And this is the Article 17 of the Copyright Directive and the way the Court of Justice has interpreted in the Poland case. I think this is really, really an important move. And one case is particular in that regard is the VOB case by the Court of Justice, and you have written the opinion. And I think that what is interesting here is that the Court of Justice, strongly supported by you, said actually libraries have a crucial role in our society. And this role should not be only mediated by market. So we should interpret the regime of public lending as applicable fully in the digital environment, even with some adaptations, of course. This is the first evolution. The second evolution is what I call the fundamentalization of exception, so the meeting between exception and the fundamental rights. And its epitome might be the three-court decision in 2019 about copyright exception, where, again, you wrote the opinion, and actually that says that exceptions are users' rights, particularly when they are justified by fundamental rights, and it even leads to say that exception may or even must be transposed by the member states. There is still a bemol, I would say, because it said at some point fundamental rights should be guaranteed, so it means that states should implement those exceptions, but fundamental rights should be confined to those exceptions and should not be actionable as such as a defense for a copyright infringement, so beyond the case of an exception. So those are two different things that have moved forward, I would say, in the last 15 years of copyright in the European Union. It leaves us with some ambiguities or some conundrums, I would say, and we can find those conundrums in the Court of Justice case law that has to balance between what was before and this more prominent rule of copyright exception. There is the issue of what we do with the strict interpretation. Can we move to a more theological interpretation to try to ensure that exception plays its role? We cannot extend the scope of an exception. We agree on that, but sometimes we can agree that some ancillary uses might be part of what is allowed. Then there is the question of harmonization versus the freedom of the states. There is this, the list of 2001 leaves some discretion to the member states to implement, but there is this obligation to implement. And what about the conditions of the exceptions? And then the last point that I raised is the fact that exceptions are seen as fundamental rights, but fundamental rights are not seen in some decision and in the 2019 decision as exceptions to copyright, because you cannot rely on the fundamental right as such to defeat copyright infringement, even though your use would be fully justified by freedom of expression and would stay in balance with copyright, because there's still this notion of balance that is important. So what do we do now? And what we do now, I would suggest that we could move forward, we could go further than what is here in the copyright landscape of European Union. First, exception as enabling devices. Actually, we should continue in that reflection for most exceptions, because it would accomplish the copyright objective that for me is about organizing a cultural public sphere and a market too, I agree. But there is also, beyond the market, there are some places where copyright is about making the work circulate and enabling a dialogic culture where users and other institutions can also participate to the circulation of works and to the access and reception of work. That would mean, in my view, to unlimit exception and limitation. So don't get me wrong here. It's not that exceptions and limitation would be without limits, you know, that they would be out of the cage and they could do whatever they want. It's not my point. It's the fact that we should stop viewing copyright exceptions and limitation as limitations of rights. They should be put within the regulation of copyright, not at the same level that copyright exclusive right or related exclusive rights, not my point, but they should play a role in that cultural public sphere in their right place, but we should conceive exception as some rule that is there to fulfill some purpose in terms of culture, access to information, access to knowledge, competition, innovation, whatever the purpose is. And that design of the exception should allow some flexibility and some flexibility in scope, but also in interpretation. So the strict interpretation should really leave some place for a more theological interpretation. And then I don't mean to say that we should reduce the exclusive rights and remuneration of rights owners. That's not true. And I would even say that for some copyright exception, a remuneration of the copyright owners could completely be conceived. The problem is also the allocation of cost. Who would pay for that? Would it be the users? Would it be the institution? Would it be the public authorities? Because most of the institutions that I talked to you about, the cultural heritage institution, they are paid by the states. And we know that today the public budget of states is really in peril. So it is a real policy choice to make. But I think those are the future. The last point is about the fundamentalization of exception. That has already gone a long way, and I don't mean to stop it. I think it should continue to its conclusion, saying that exceptions should be mandatory for member states when they are grounded in fundamental rights, or the use that they permit should be allowed under different grounds. And the different grounds could be the fundamental rights themselves. You have some countries who don't know a parody exception, but they allow parody because of freedom of expression directly. And here I would disagree with you, I'm sorry to say, but I think that fundamental rights should be defended as such without the need to find their place into a copyright exception. Thank you.
So, thank you very much, Séverine. It's extremely, again, interesting and thought-stimulating. And I would like to ask you a question. So, on a specific topic, so how would you assess the impact of the secondary publication right on research and on the scientific publishing sector as a whole?
Okay, so it's not a question completely or directly related to exception, but it's completely related to my point to say that copyright should be about organizing the circulation of work, the reuse of work, access to works, etc., for innovation, for culture, for information, for education, etc. So the secondary publication right is not an exception, because in a way it is a right that I, as a scientific author, should keep. So even if I transfer my copyright to publisher, I tend not to agree to do that, and I tend to resist not to do that. But you know, if I have transferred my copyright to some publisher in my scientific article, I should be able to retain this right to publish it on open access repository, because it is feeding a thriving scientific community, which is part also of the objective of copyright, I think. So this is the sort of rule that would actually also enable some objective of copyright and not leaving everything to the market. So not saying that publishers will do their job to make their scientific publication circulate. They will do that. The scientific publication will have a market of their own. But in exchange, between researchers, the open access repository are really important, particularly for people who don't get the financial means to get the scientific article through the market, the young researcher, the researcher from the global south, etc. And I think it's really important. And it's also a matter of fundamental right of research. That is a right that is part of the architecture of the fundamental rights in Europe.